Right. So back in the Judiciary Committee this afternoon, Friday, April 28th. And S4, an act relating to reducing crimes of violence associated with the juvenile and dangerous weapons, juveniles and dangerous weapons. Eric is kind of caught up still on the Senate floor on page 230, so that's why he's not here yet, but passing out a version that my understanding reflects our conversations yesterday. So I did have, before we look at this, and I had one additional issue that I've been thinking a little longer about, want some more input.
You need more.
But I received an email. Oh, where is it? There's just too many emails. Just a second. Unless I deleted it. No, I didn't. From the Vermont League of City and Towns weighing in to support Representative Harrison's amendment if there is an opportunity. I was putting that one aside because it seemed like it may be a little bit of it's not a very heavy lift, but things are heavier this time of year, and whether we'd be able to vet that sufficiently to put it into S4 or S33. I wanted other folks' input. I still see that we would need to hear from more people than just the Vermont League of Cities and Towns. And the language I've seen so far, doesn't really impress me. And I think maybe this is one that it's not going to help in the next 6 months or 8 or 10 months, a year, whatever, for Jim. But I mean, I think it deserves a deeper look. It's kind of where I am, but I'm open to other viewpoints. Anyone have any?
Yeah. No, and I do agree with, I mean, I probably wouldn't support it no matter what, but it definitely deserves a deeper look. I mean, we're at the end of the session. To get everybody in here, I mean, if we did throw it in there, just going to be accused of rushing it through and jamming it in. And those types of arguments, no matter if you support something or not, it's just not worth having that happen.
And when I talked to Jim earlier this session, and he brought this possibility up, I said, sure, when we get to S4, happy to take a look at it. Just from talking to him back then, I thought it would be straightforward. I thought it would be something that would be that hard to slip into this particular bill because presumably Jim was going to also do any kind of greasing of skids to make sure he may have, I think he did try, but it was more controversial than anticipated and needing to build a record if they're going to do something that's controversial. So
where was the league on it?
They're in favor of it.
Okay.
Do we have the amendment?
Yeah, so it was handed out the day you were gone.
Okay, so I'll just look it up.
Of course, then there's the issues with the Sportsman's Bill of Rights, whether or not it
Allowing municipalities to ban
Right.
firearms from town-owned buildings.
Allowing municipalities to decide not to have firearms in their buildings, which also in talking to Tucker, that they probably already have the authority to post to say firearms shouldn't be inside the building. That's a little bit different, I guess, than restrictions that they're thinking about and actually having an ordinance with possible consequences, fines, etc. I mean, I think it's a good idea. I'd like to see it, but I just don't see it happening this year.
We're going to put it on the list for.
Yeah, we can definitely continue that. At least that's where I was. The other related one is the exceptions for the ban on firearms in hospitals. And we actually learned through our discussions on the forensic unit and those things that Department of Corrections, like Tom explained this to us, Department of Corrections sometimes have to be there in the hospital, and right now they don't have an exception for having a firearm in the hospital. There's also not an exception for if there's a private security guard of some sort who is licensed. They are also not allowed to have a firearm in a hospital. I did run this language by Jessa Barquist and Devin, and they made one small suggestion on the, the private security in the hospital, but otherwise we're fine with it, just for folks to know. So I would like to put that somewhere. The question is whether to put it in S4, which is already has a bumpy enough road, or if I put it into S33, but I would need to see where people are with expanding those exceptions.
So interestingly enough, from what I understand, is that off-duty police officers can't have their firearm on them when they go into a hospital. And they have more training than anybody. And also, you can, even with the new law?
I think you're always kind of on duty.
We're always on duty.
Oh, okay.
Depends on the SOP of the department.
Okay, then
But
I
most
got
of the time, we're all.
right. Okay, I got some wrong information there. Then,
Yeah.
and also
That was my understanding last year when we took this.
off-duty service members can't carry in a hospital. That one's a for sure, which I find interesting. I mean, and they have more training than what the security guard is going to get. Chances are. But I just found it interesting that somebody who serves our country and part of the thing that they do is in that type of thing. I'm not necessarily advocating for it. I wouldn't have an issue if it was expanded to.
So you would not have an issue if it was expanded?
So it's service members that are, I don't know if the right term is active duty, but like if you've got a guard member who's a 9 to 5er and 5:01, 5 o'clock, he can carry it in the building. 5:01, he can't because he's off duty for the day.
Right.
They're typically not armed in stateside.
Say again?
Typically not armed stateside.
Yeah, but that would go with Army, Air Force.
Right.
That's everybody.
So I think the idea here is that if National Guard has been called out for some sort of emergency, that if it also involves going to a hospital, because the language we have is that
Yes,
National Guard
because they're
members
on duty
on
now.
duty and acting under state or federal orders.
Yeah.
So I think expanding that one, I think we would need to look at a lot more things on that. But so have folks seen this language? I mean, you should have it. It was passed out. We talked about it at one time. I don't know if, do we need to, it was when we looked at it was when we looked at S4 and Chris Bradley did comment on it. We had testimony, Chris Bradley, Allison, she both had the opportunity to talk to it. If people could find that and tell me, if there's anybody has any issues with it. Ella, do you have a question or?
I was just going to say, it feels like, first of all, we're correcting an oversight that was made when this bill was brought the first time.
That's how it was brought to me.
And we need these people to be able to access hospitals on duty in particular, so that we can take care of public safety. And I guess I just feel like that this should not be hard to pass. And we haven't heard from anybody who has any concerns about it.
Right.
And I would personally, I know there's probably some technicalities to consider, but personally, I think this should go in the miscellaneous bill because it feels very uncontroversial and
That's a good idea.
it's really important. Like, I don't want to put this off
Yeah.
for some reason or have it fall apart in conference committee when we're trying to make sure people can get in and take care of an emergency. And the fine, the penalty here is $250 fine. We're not talking about a misdemeanor. So
Right.
just wanted to point those things out and encourage it to be attached to the miscellaneous bill.
This is S4? S4?
No.
S6.
This is just the one page about fixing the firearms in hospital building prohibition to expand to include other kinds of public safety, armed public safety folks.
And we can, if people have it in front of them and are willing or ready to do a straw poll on whether to put it in the into the miscellaneous bill.
I'm looking for it.
Happy to share my copy.
Well, and I'm going to tell you the,
Will change.
yeah, I'm looking for the change.
So is the change just that the only exception was that number one, a federal law enforcement officer or a law enforcement officer certified as a law enforcement officer by the Vermont Criminal Justice Training Council?
Right, and now we're adding 4 other types of public safety folks that we apparently forgot about, including hospital security. To be able to be honest.
That's for official duties, okay, so looking at if.
It's more safe.
So if you're looking at it, the security, the number 2, here's the suggested change. A security guard or private investigator performing the security guards or private investigators' official duties, and here's the new language, on behalf of the hospital, who is licensed under 26 VSA Chapter 59 and possesses firearms certification issued under 26 VSA Section 3175. See, just to make extra clear that we're talking that those official duties are on behalf of the hospital. Do people, I mean, when we're like just a straw poll, we're getting it into the miscellaneous bill. We will see the miscellaneous bill again if there's like any tweaking that people want for it. And if at that point people say, yeah, I no longer like it, we can take it out still. But I'm just trying to get these things added in where we have consensus that it's something that we should add in. Are folks ready to do a straw poll on this? Ben, are you ready? Are you good?
I don't know. Fine, doesn't matter. Thanks.
We're waiting for Sean.
That was the only change, official duties.
And on behalf of the hospital, on behalf of.
So as far as law enforcement and everything, we were okay with this, right, Tom? I mean, Tim's in here. I mean, you didn't have a problem with this one, did he?
I didn't think he even thought he needed to weigh in on this one. This is
My brain was elsewhere.
this is the exceptions for law enforcement or for different folks and yeah.
Oh.
Yeah. I read it.
No, I think I'm fine with this.
Yeah, no, that's right. So all those in favor of at least putting it into S33, although we'll have some more time to look at it, raise your hand. No, not in favor?
I mean, sure.
Is that like a reluctant half, like?
It's just it's gonna take a lot
Yes, no, and maybe on the list.
for me to vote in favor of more guns anywhere in our society, so. I get it.
Fair enough. I understand where you're coming from. All right, so I'll ask Eric to put that in there as opposed to an S4, because I had suggested S4. All right, so Michelle's on her way up, so we will postpone S4 further discussion to probably right after the floor when we can have Eric. And I am still hoping to talk about S6. Hello. Nice to see you again.
Only 2 left.
I've definitely done my part.
All right, so we are turning to the Senate proposal to the Honorable Senate. Who's it from? It's to the Honorable Senate.
From the Committee on Judiciary.
Oh, okay. Can we strike? It's well put, well put. All right, so over to you. It's come over, it's on its way over. I haven't seen it on the calendar yet, but the way calendars are moving, it could be up.
Senator Sears was out this week, and so he's going to be back on Tuesday. And
It hasn't handed it
he
in,
hasn't
so
handed it in
it
yet.
might be later next week.
Yes, it'll be later next week, but it was voted out yesterday.
Okay, well, might as well go over it.
Yeah, sure. So, just as a reminder, so we're working off the abusive litigation, and there's no substantive changes to the proposal of amendment. The only changes that have been made are in section 1, in the definition section, the definition of abusive litigation. And then there's one change to on page 4, section 1182, but they're just technical. Abusive litigation, again, substantively is the same exact as yours. I just kind of reconfigured it with Judge Zone. And I think it actually is more readable, more accessible in terms of that. And so I'll just kind of go over that definition, just recognizing that it looks a little different, but it's the same substantively as yours. So abusive litigation means litigation where the following criteria are all found to have been established. So there's 4. The first one is the relationship between the parties, that being that the opposing parties have either a current or former family or household membership relationship, or there's been a civil order or a criminal conviction determining that one of the parties stalked or sexually assaulted the other party. Second requirement is that the party who's filing or initiating, advancing the litigation has been found by a court to have abused, stalked, or sexually assaulted the other party. And then you'll see starting at the top of page 2, and those are all the ways in which the things that would establish to the court that the party who is filing the litigation has abused the survivor. So the first one being it's a final APO under Title 15. Second one is that it would be a final order issued under Title 12 for the orders against stalking or sexual assault. Subdivision 3 is essentially just a final foreign abuse prevention order. So we're not talking about emergency or temporary orders, they're just final orders. Next is an order under parental rights and responsibilities that provides for special conditions around a parent-child contact order if there's been established that there's domestic violence between those parties. And then the final one, there's 2 more. Then 5 is that there's a conviction for either domestic assault, stalking, or sexual assault. And then the last one is that a court has made a determination of probable cause where the person who's initiating the litigation has gone before the court and been arraigned on domestic assault charge, and then the court has imposed conditions of release around protecting the victim in that circumstance. So again, those are all things that you guys put in there. And then so the third requirement is that the litigation is being initiated, advanced, or continued primarily for the purpose of abusing, harassing, intimidating, threatening, or maintaining contact with the other party. And you'll recall that later on in the section around the hearing process, there's things that can help guide the court in making the determination about whether or not the purpose of it is primarily to be harassing or maintaining contact with the survivor. And then the fourth requirement is that at least one of the following applies. The claims, allegations, or legal contentions are not warranted either by existing law or by some type of reasonable argument for a modification of existing law. Page 3, next one is that the allegations and other factual contentions are without adequate evidence, and that upon kind of a reasonable extension of time and looking into it, that they're unlikely to have evidentiary evidence. And then the final one is that an issue or issues that are the basis for the litigation has previously already been filed in other courts and has been litigated and disposed of unfavorably to the party who's filing the new litigation. So again, just kind of reworked, but the same thing that you had. And then the other change is that if you look at page 4, section 1182, and in section 1182 in the House version, the subsection A was just kind of like a restatement of the definition section, and it was kind of awkward. We were kind of going based on what the law was in like legislation in other states, and I think this is a better approach. And so I just basically took that out and said instead a party who meets the requirements of, and then refers back to the elements of the definition, may request an order restricting abusive litigation, and then go. So I really think it's just kind of clean up language, and I think it all maintains your intent and your policy. But I think the language actually is a little clearer.
So Ella, you reported this originally, or was it Karen, or was you? Okay. I started at one end of the table and just kept on going until I landed there. So,
Yes,
so do you have particular questions?
Yeah. Well, you know what? I don't have particular questions, but I do have one question, I guess, but it's not necessarily related to the Senate changes. I have discovered in the revenge porn law, like, if it's not the ex, but like the ex's girlfriend. So I don't know if there's anything that needs to be added that says, or somebody sort of, this isn't the right language, put up to doing it on behalf of the person. Because that has kept us from, so basically it may not be the ex because the ex might be told.
Well, then it's not covered.
Right. But if the ex is saying, if I'm like, Karen, you need to put it in for me this time because I can't put it in, like that, like it seems like, or somebody who initiates it, and maybe we don't want to make changes at this point, but I think it's something we should keep an eye out for because it does sound like there are sort of workarounds.
Well, I will say that, you know, the majority of these cases are going to be most likely in the family division,
Right.
and often involve when there are minor children, you know, I mean, like it's,
Right.
so it wouldn't be
So that
like
wouldn't
the
be-
girlfriend
Yeah.
or you can hear from,
Yeah.
you know, witnesses on that. But I don't think when you have, again, that first requirement that it's, the person has, you know, abused in some way, the person, you have to establish that.
Right.
Right, and so I
Okay.
think it's not to say that you don't have a policy concern or issue there, but I don't think that this is the way,
That's pertinent to this.
it doesn't really dovetail with
That's good.
this.
Any other questions on this? I don't see any. I think we should wait for it to actually get passed out of the Senate before we have a straw poll, just in case something happens. Or if people are prepared to do a straw poll, we can do it now and just get confirmation that nothing has changed from this. When it's all in everybody's face.
Let's do it now. Let's figure it out.
Right, exactly.
I can't hear in that range really.
It's not gonna take any more time either way, we're gonna bring it up again anyway.
But we'll have Michelle do another
Need more
walkthrough.
time. Need more
I
time.
mean, if we get the information from the Senate, all we gotta say is there's no changes and go, done.
Right.
Which would take us the same amount of time.
It'll give Kenny enough time to read it as well.
And coach.
And coach. So we're not gonna go over that because.
Okay, I will, as soon as it clears third reading over there, I shall let you know and let you know if there were any changes or if it went as you've seen it.
Excellent, thank you.
You're welcome.
And we will turn back to, since we have time and Eric has not been able to show up yet.
Floor?
Yeah, I think they just went back to, was that a roll call that they just?
I didn't see it blinking, so I think they had a roll call.
All right, so we might be seeing Eric soon, but
They're about to blinking and not blinking. I didn't even see it. It's hard to with all this train results.
All right, y'all have a good weekend.
Thank you.
Bye.
so a couple things on, back to S4.
Well, okay.
Um, Eric have any- So rather, let's still wait for Eric to kind of give us a walkthrough on this. See. Don't see that there's one, I wanted to, all right, doesn't matter.
Did he highlight the things from yesterday?
He did. It's just that there's one thing that I'm not seeing that's in here that I thought he was going to put in here, but that's fine. We're still working on this. So I wanted to talk a little bit further about landlord provisions. And I still have felt that there's been still some angst about the recklessly provision and what that could do as far as landlords being more skeptical perhaps on certain individuals who want to rent, and would welcome any kind of further discussion on that language. We could still potentially take that out. And the one thing that we would be doing is increasing the fine and getting rid of dispensing. But I will say also, the language as far as the landlord, let me see, the human trafficking, that's a whole new offense. And so we would definitely be adding that, but as a misdemeanor. Any viewpoints on recklessly? I mean, I just have felt that that's kind of the one area that I didn't feel that we nailed down.
Has housing in general looked at this?
Not to my knowledge. Paula?
And I'll just sort of reiterate, I have a lot of concerns about this section and, as maybe inferred from Barbara's comment, like the impact on tenants and even the impact on landlords. And the biggest thing I heard in testimony was about out-of-state landlords who aren't even present, and I'm not really sure this gets at the issue. Trying to impose more on landlords feels very, has a lot of negative risks and maybe not a lot of benefits. I did, just print out, I just did a search online if I'm a landlord in Vermont to get information about what I should do to try and reduce illegal drug use on my property. And there's very little. I wish we were investing in education, communication, and what is out there is from the U.S. Attorney's Office. And I just feel like there's a different pathway here, and I'm not excited to add anything except for the language that we've really hardly discussed. I'm not looking at it at the moment. I think it's subsection D that clarifies that if you're a landlord and you are taking action, that you can't have these penalties applied to you. So I would continue to support really reducing this, if keeping it in here at all, to taking out recklessly, I would prefer to take out the change in fees altogether, but I'm okay with the fee to 3 years for, I think you discussed divvying it up, right, Martin? So I'm not looking at the revised bill, but.
Yeah, I was looking at.
But there's we discussed two different levels.
And no, at this point, I just have.
Oh, no, we just did two.
Went to a 2-year.
Okay, good. Yes, that's what I was hoping.
We went back to that, but we raised the fine.
The only good reason to me to keep this in here at all is for subsection C. And yeah, I would prefer to take out recklessly and keep the fees there.
Anyone else? Nope.
I was thinking about this a lot last night because this is a really challenging question for me. Because on the one hand, I can see, utility in this and addressing some of the things that we heard in testimony. Two things. First of all, I taught for many years a class that a portion of the class had to do with housing discrimination. And we read, as part of that class, I had the students read Matthew Desmond's Evicted, which if people have not read it is highly, highly, highly recommended by me. I think it's one of the greatest books of the century. This section just sort of bubbled up for me that I couldn't, just kept on sort of repeating in my mind. And there was a Black woman who had been struggling throughout the book. And this is a true book. It's Desmond's a sociologist at Princeton who's a MacArthur Genius Grant Award winner. And he spent about a year and a half in Milwaukee following a group of white tenants and a group of Black tenants and sort of seeing how they interacted with sort of the legal system and landlords around housing differently. And there's this scene near the end of the book where one of the Black women who had been struggling throughout the entire time he was there and finding housing for her and her children finally found a good apartment. And her son, who was about, I think, 14 years old or something like that, was chased home by police officers for whatever reason. And ultimately the police officers left. And the landlord happened to be there that day. And he saw it. And Milwaukee, according to Desmond in this book, has this law that basically if the police respond or come to an address too many times, it creates liability for the landlord, and the landlord could end up in jail. And so she ended up, the landlord knocked on her door and said, look, we have two options here. I can't have the police showing up at this address. It opens up liability for me. Option one, I'll give you about a week to get out. Option two, I'm going to start eviction proceedings. And so what I'm worried about this is the chilling effect that it could have on people who may end up interfacing with law enforcement due to no fault of their own, and through mistake or whatever it is. And then the landlord sees that, and the landlord isn't a lawyer. They may not know what recklessly means. They've just heard from the landlords association or whatever it might be that you can be on the hook. And you don't even have to know, you can be on the hook for this. You could be in jail for 2 years, you get a $15,000 fine. And so I think, particularly based on Desmond's research, people are going to gravitate towards tenants that they think are less likely to sell drugs and things like that. And, sadly, unfortunately, we know about implicit bias, we know about explicit bias. And sadly, that could be, against people of color. And I really worry in the time that we have a housing crisis in a state where we struggle around issues of race and trying to find equity for everyone, no matter their background, the color of their skin, or anything like that. I'm not saying that law enforcement is biased. I'm not saying that even landlords are necessarily explicitly biased. Even there's certainly research that shows that landlords can be. But we know about implicit bias. We know that there's implicit bias, particularly to think that people of color are more likely to commit certain crimes. And what does this do to people being able to get housing, and people being able to sign a lease and have a place to live that's going to be affordable to them? And it really, really worries me. And I feel like, the other piece of this is that I felt like I just kept on asking the same question over and over again. What's recklessly? What's recklessly? What's recklessly? Give me an example of recklessly. And the answer I got every time was pretty much a knowing situation. The landlord knows, the landlord's seen, the landlord got a notice from the police, and I just kept on saying to myself, that's not reckless, that's knowing. And so I ask myself, what does this add? And what does it cost? And I think that there very well could be some unintended consequences and unintended costs on tenants being able to find affordable housing here. And as Ella said, I wonder, is there another way to get at this problem that is a real problem? and a problem that we really need to address. I mean, hearing the testimony about what's going on, it's completely unacceptable. And it is unacceptable to me that there's these landlords who are not intervening, because there is a statute on the books. We aren't adding this. The only thing we'd be really adding is the word recklessly. So, like, why aren't they being prosecuted? No one ever answered the question, what's wrong with this statute right now? Why aren't they being prosecuted right now? What's the piece that's missing? And again, we also didn't really hear a lot of testimony about what the impact on the housing market could be. We are somewhat speculating about that right now, but, in the past 48 hours, I've gotten email after email from organizations who advocate for people of color in the state of Vermont, saying, no one asked us about this. We just heard about this 72 hours ago. And, maybe this is appropriate, but sort of like what we were saying a few moments ago about the amendments regarding potentially banning guns, at the municipality's choice for municipality buildings. Have we really heard enough testimony and enough evidence to be able to feel confident that this won't hurt people at a time when our housing crisis is so bad? So that's what I've been struggling with this.
Karen.
I think I'll be much more brief. Appreciate the comments, Al. I am open to removing it. I think one of my first comments I have on it is remove. This doesn't seem easy to define. And I feel like we haven't heard testimony or overwhelming that it was necessary, that it was needed. I do think it creates more opportunities for discrimination. And I think how it is without it allows us to move forward. I could also be open to getting rid of the whole section, but that probably is going too far. But recklessly, I don't see that's needed.
Yeah.
I guess the question I have is why was it put there in the first place? And is recklessly used in law anywhere else?
Yeah. Yes, it's used on.
So is the right term, is it established in law?
It is, and it's established by case law, is I think where we decided. It's not really defined elsewhere in statute, but it is. I remember.
It's the jury instruction for recklessly. The state must have proven that the defendant acted recklessly. You may find that the defendant acted recklessly if she consciously ignored a substantial and unjustifiable risk that his or her conduct would cause alleged harm, his or her disregard of the risk when considered in light of the nature and purpose of his or her conduct, and the circumstances known to him or her must have been a gross deviation from how a law-abiding person would have acted in the same situation. That was from August 28th, 2020.
So aggravated assault has a person guilty of aggravated assault if the person attempts to cause serious bodily injury to another or causes such injury purposely, knowingly, or recklessly under circumstances manifesting extreme indifference to the value of human life. Simple assault also has a person guilty of simple assault attempts if he or she attempts to cause or purposely, knowing, or recklessly causes bodily injury to another. And I'm sure there are other examples, but that's two that Tim Legers-Dumont was kind enough to mail me earlier this week. So yeah, it is used, but I'm here, certainly hearing the concerns on recklessly. Barbara, have you figured out a position where you are yet? Thinking about it still?
It sounds like it's complicated, and my sense is we haven't taken enough specific testimony or sent it to a committee that might do that.
Angela, where?
Yeah, I think when I do the potential benefit, potential cost analysis in weighing those two, I definitely come out with a concern that the potential drawbacks, and again, I don't know for sure, but the potential drawbacks are outweigh what I think of as the potential upside with the change to recklessly. So I would support removing it. I also feel, like I said, I think from day one of this bill, it was a question I just asked sort of as an aside to Eric, who wasn't in a position to answer it. But again, juveniles are not landlords. This is supposed to be a bill dealing with juveniles and crimes, dangerous weapons. There seem to be a lot of assumptions built into the inclusion of this section in this particular bill. And that makes me a little uncomfortable, just that this whole bill feels like it was tailored for a specific situation, a specific set of circumstances in a specific town or county in Vermont. And that doesn't sit great with me. This feels like one of the most obvious examples of that.
All right. Will, where are you?
So, we can talk about the legal definitions and parse the wording, but, recklessly seems like a very weighted word to me. And I worry that it throws the rest of the language, the rest of the intent is here sort of off balance. It's not a deal breaker for me one way or the other, but as we continue to work our way through this challenging bill, I would feel more comfortable removing recklessly.
I appreciate that. Well, I count at least 6, and I haven't heard from me or Coach. So I'm going to suggest, Eric, that we take out recklessly at this point. I'm looking at draft number 1.1, page 8, line 5, page 9, line 4. All right. You concur?
Yes.
Okay.
Just everything that was being said with regards to the clearly stated feeling. So not to be, it was well said. So I appreciate it.
All right, so we can perhaps have Eric join for a walkthrough of the latest revision, if that's okay, Eric, if you're available?
I'm
or not?
available, definitely. I seem to not have a copy of it.
Okay, all right.
I came right here from the Senate floor, and I thought I had my file with me, and I didn't. So,
I'm sure that we can get you a copy.
You can use mine to start.
Perfect.
We do have an extra.
How'd it go? How'd it go? Are you, was it any significant changes on the floor or?
no significant changes on the floor.
Okay.
There's a couple, there's a number of changes. Oh, thank you very much.
Yeah, no, I understood. I've been kind of keeping up with folks that there are changes.
Right. No, any board members?
Okay, is the waiting period still intact?
Yes.
It keeps.
Okay.
Waiting period still 72 hours.
Okay.
The ERPO provision has a different standard for if a family member or household member files it, so they raised that to clear and convincing.
What do you have, 6?
That's S6, that's not.
Oh,
Oh, right.
Don't start with that.
We're up there. That's
I've never read before.
That's okay. You can start.
Oh, there we go. Thank you.
Not that we haven't had one or two.
Right. Let's see. Move on to this. In other words, don't give any further follow-up on the H230. Wait for that.
We'll get you scheduled again for Tuesday. Do you know if they're moving things, suspending rules or anything like that? I'm just kind of.
I don't think they are now. But,
So it would be
it'll be on the Senate floor for third reading Tuesday.
Tuesday.
Yeah.
Oh, they're not doing, oh, yeah, because, all right, Tuesday, all right. Okay, so we'll have time to fit it in. That's all I'm just thinking, whether that we'd have to do that.
Sure.
Morning or not.
Yep, sounds good. So Eric Fitzpatrick with the Office of Legislative Counsel, here to talk with the committee about a proposed possible amendment, or at least the first iteration of the committee amendment to S4. The idea is to incorporate some of the discussion that the committee had yesterday. And again, it's first draft, so it may or may not get all of that correct, but I was hopefully got at least a good chunk of what the committee was leaning toward based on yesterday's discussion of the bill. So, and thanks to Rep. Chapin for providing me with an actual copy of the bill. Appreciate that. And so the highlights show where the changes are. I'll jump right into section 1, which you, of course, remember by now is the provision regarding what's currently known as the Big 12. It's the idea being that these are the listed offenses which have to start in the criminal division of the family court when a person right now, age 18 or younger, commits this illegal conduct. So generally speaking, illegal conduct committed by a person of that age starts in the family division. There's a certain listed group of offenses that start in the criminal division, nowadays known as the Big 12 because there are 12 of them. The proposal here is to expand that list. At least that was the proposal the Senate made, and this committee was discussing that yesterday. So you see several of those proposals, 13 through 16, bottom of page 2 over the top of page 3. Carrying a firearm while committing a felony, trafficking a regulated drug, human trafficking, and aggravated stalking are all struck from here. And if you flip for a moment to page 19. Yes. Lines 8 through 14.
Okay, because I was like, I don't have a 19. Okay, so it's in here, I'm sure. Yeah,
They seem to expand.
here it is. Okay.
Okay.
Thank you. Sorry.
So you see those offenses are now placed. So they're not removed from the bill entirely. They were in the list of expanded Big 12 offenses. And now you recall this section of the bill is the part that asks the Sentencing Commission to think about whether or not the Big 12 should be expanded. And there's this long list of offenses for them to consider. The reason that list is what it is, by the way, is because as the proposal originally came over from the governor's office, all of these offenses were in the Big 12 expansion. So Big 12 was originally proposed by the governor to be substantially broader than it was in the bill. So the Senate Judiciary Committee cut that list back and said they took the vast majority of those offenses out of that request from the governor's office and put it into this study by the Sentencing Commission. A little background.
How does that work where you say it comes from the governor, like
The governor's
They can't-
office proposed it.
proposed it?
Yeah.
Be submitted in, because they can't draft legislation, so they just,
Well, it's like any other time they request legislation, any other agency, that you request a change or anything like that.
okay, well, the part of this process they did.
Yeah.
Okay.
Well, the governor's office testified on, this is the one that Jay was in here on, right?
Yeah. Yeah.
Yes, now I get it. I thought that they just like put in a special request to
Well, I'm not giving you a hard time. I'm trying to,
No.
catch up where,
well, I know, I'm just trying to S6, S4,
Just amazing that they would.
proposals, amendments.
32,
Busy.
right? Or the big.
It's hard to keep it all straight. I'll back you on that one, Representative. So for these four offenses were in the bill that the Senate passed, 817 through 20, now on page 19. Proposal I think that the committee was thinking about yesterday was take those four out of the Big 12, put them in this list of ones for the Sentencing Commission to think about going forward. So hence their relocation. Back to page 3. So subdivision 18 now. This, you remember, was the idea that another addition to the Big 12 would be a.
What page we on now, Eric? 3. Back to 3. Okay.
Bounce back and
More number.
Yes.
Are we back on the ping pong thing here?
That is kind of an
I'm
example.
feeling, it's not a ping pong, I'm a yo-yo.
Right.
Well,
Well, that idea.
I can't disagree with that.
Yeah, nobody's disagreeing.
But you're right that I just ping ponged. I ping ponged to the back of the bill and then ping pong back to the front.
Forget about all that.
I heard it.
I didn't.
That wasn't laughing.
Thanks, Barb.
I was smiling,
Ladies.
laughing inside.
So I'm about to ping pong again, I have to tell you, because
Here's a.
It's the ricochet, now we're
I was hoping you were
ricochet.
gonna ping pong on number 18.
I was.
I couldn't find the fix. so-
Right. I know, it feels like it's gone. Where could it be?
Yeah.
Not only is it Friday, it's getting toward the end of the session, so it's double punchy time.
Yes, right. I didn't eat lunch. I haven't eaten since like this morning because I was starting to get a little lightheaded.
Cheez-Its, give them some
Chocolate? Chocolate?
Cheez-Its, Cheez-Its, we got Cheez-Its.
I like sugar, not. Yeah.
To make it to the next
Yeah,
meal.
exactly.
You know, your glucose will spike, so you should have some protein with your chocolate, like some Monster.
Thank you.
Oh, my God, just
All right.
that.
Hand them over.
You know what goes good with chocolate? More chocolate.
Thank you. Thank you. All right, back to our story. The, right,
Okay.
It's 3.
All right, so
there you
yeah,
go.
back on page.
So this is the issue of trying to keep criminal proceedings or juvenile proceedings together when it's the underlying criminal offense and a violation of conditions of release for the same offense.
Ooh, that's.
Proposal had been to
Doing construction.
say that, all right, any violation of a conditions of release for any one of these listed offenses, whatever the final number ends up being, would also be a Big 12 offense. In other words, that would also be in the criminal division, because otherwise, because a violation of conditions of release is a misdemeanor, that would ordinarily be brought in the family division. So if the case is in the criminal division because it's a Big 12, but someone violates the conditions of release, well, that would be in the family division, because it's a separate misdemeanor offense. So here you've got the same defendant, the same offense being involved, and you've got it going on in 2 different courts, 2 different judges. So the idea is an efficiency one to try and consolidate it somehow. So
Just left it in.
but the committee didn't like the idea of it being a Big 12. I think understood the idea of trying to keep things together, but not necessarily calling it a Big 12, because it probably, I think, would be the only misdemeanor offense that probably would be a Big 12 if it were. So the proposal here is to move it forward to page 6. So here is, and it didn't really make sense to keep it in that section of statute, because that statute is about transfers. And you're not talking about a transfer now. You're talking about, you want this case to just start and be in the criminal division. So that makes more sense to have it in a different section of the juvenile law. You see it starts on the bottom of page 6 about where offenses are commenced. Where do these offenses start? And it depends on what type of offense it is, right? So if you look at the top of page 7, existing law lines 1 through 6. That is the existing law that states, even though it's a bit wordy in the way it states it, what I said earlier, which is that if it's a Big 12 offense, it starts in the criminal division. That's what lines 1 through 4 say. If there's a cross reference, but the upshot of that is if it's a child who's 14 to 21, it starts in the criminal division. That's what that means. And then it says after that, provided that jurisdiction may be transferred. So that means that, as we've talked about before, although they start there, there is a motion process and a hearing process to get it transferred. So it takes some process, but it can be done. And the last piece, unless the state's attorney directly files the charge as a youthful offender in the family division. That we've also mentioned before. That if it's one of these Big 12 offenses, the state's attorney's options are file it as a criminal case or as a youthful offender case in the family division. Those are the 2 options. So what this does, what you see on the rest of page 7, is just takes that same concept of if it's a violation of conditions of release and says that's got to be filed here too. That's got to be filed in the criminal division as well. So that line 7 through 12 is just pretty much verbatim, a repeat of what we just looked at on lines 1 through 6. Just says the same thing. Any Big 12 offense, right, shall originate in the criminal division. Again, says the same thing, although it could be transferred or it could be filed as a youthful offender. If it's one of these following things, and what are these following things? Starts on line 13, violation of conditions of release for a Big 12 offense. That's what that means. I know there's a lot of cross references there, but what that's saying, some Roman numeral, lowercase Roman numeral I, 1, lines 13 to 15. That's saying, all right, it's a violation of conditions of release for a Big 12 offense. It's filed in the criminal division. Subdivision 2, line 16 through 18. If it's a violation of conditions release for an offense that was transferred to the family division. So that was another piece of what was in before, because another way that a case could get to the criminal division is it could be transferred up, right? Because there's a bunch of other felonies that aren't Big 12 felonies that there can be a motion in the family division saying, this case is more appropriate in the criminal division, let's transfer this up. So that would be another situation where you'd want the conditions of release and the crime to be in the same court, not for them to be in two different places. So that's why that's saying, all right, if it comes up to the criminal division in that fashion, also conditions of release will be filed in the criminal division as well, because that's where the criminal case is going on. And then lastly, subdivision 2, and all this was exactly in the piece that was struck several pages earlier. Same principle here, which is that, well, remember that what also can happen is that once the case is in the criminal division, and this is kind of a little bit related to ping pong, but a case in the criminal division can get transferred to the family division for youthful offender treatment. And if that's the case, well, then you don't want the violation of conditions of release being filed in the criminal division, because the case is gone. It left, went back to the family division for youthful offender treatment. And that's what subdivision B is saying. It says, hey, this doesn't apply if the case got transferred back to the family division for youthful offender treatment. Then you don't file it. You don't file it here, because that would make sense, because then they would still be separate. So that's the big picture. A lot of technical language there, but that's kind of the big picture. Just taking that same concept from where it was before, putting it here. So it's not a Big 12 offense. It's not adding to the Big 12, but it is saying, hey, try and keep these proceedings together.
Can I ask a question that's not about this copy as much as the bill? Is that okay? So I'm having a hard time, because I see the title of the bill is an act relating to reducing crimes of violence associated with juveniles.
And dangerous weapons.
And dangerous weapons, yes. But even just the first part. And I don't know if the Senate did this or how they came about the items they put in the bill, because like study after study shows that juveniles are more likely to reoffend if they're transferred to adult courts, and states are moving to fewer crimes that are carved out for juveniles to be tried as adults and treated as adults. And we already have a D rating with our current law. So I'm really confused about why the Senate picked this plan.
It's a question for Eric.
Okay. I'll hold my question for, I don't know. It's just.
You can go ask Senator
puzzling.
Sears.
Okay.
Can I ask a traffic
Yeah.
question? I'm just wondering why you have to repeat, sort of like why you're repeating like C1 and then 2A.
Yeah, it wasn't really fitting.
Okay.
Because it was just, because my initial thought always too is not to repeat language when you don't have to, but it just wasn't finding a way, because the C1 is specifically applying to the Big 12 offenses.
Yeah. So this is a way of adding to that without
adding to it.
Okay.
Exactly.
Gotcha.
Right.
Okay. All right.
I have a drafting question.
Go ahead. Yeah.
Going back to the previous section,
Section 1.
Section 1.
Yep.
The last, the thing that gets a ping pong effect at the end of section 1. Right, that's on page 6. Yes. On page 6.
Oh, yes, yep, sorry.
It's section 3.
Right.
Could that move to this new 5201? I wouldn't mind getting rid of section 1 altogether and just focusing on this new section that you put together that seems to be where there is general agreement that these are good improvements.
You certainly could. The reason I put it there, to be frank, is because if you look at the subdivision above that, it's very much related to that. That's also a stipulation about transfer. So, but doesn't mean you couldn't put it elsewhere if you had another reason to do that. You certainly
Now
could.
you're trying to pull stuff out.
Right.
All righty. So, Ken, and then Tom.
So I think Barb said this, and I'm questioning it. And why did the carrying a firearm with committing a felony get taken out when this bill, violence associated with juveniles and dangerous weapons?
Wait, what are you talking about? Can you point out where you're talking
Well,
about?
it's 13 on the Big 12. I mean, why would that be taken out when that's what the bill says?
It's moved.
Because of the hour and a half conversation we had about that last night.
Thank you. So where's it moved? Somebody said
It's
it's moved.
moved to the study and the sentencing commission.
Yeah, page 19.
Thank you.
Section 2.
Section
8. So I heard while I was listening a few minutes ago so this is the permitting a dwelling or a building to be used, and section 2, 3 thinking about them together because they're very similar concepts. Permitting the dwelling to be used for either sale of drugs or human trafficking. I think the conclusion is to strike recklessly, correct? So that's one piece that Am I right on this?
Yep.
Sorry.
Yes.
No.
Sure. Okay, thank you.
He's not listening to me.
I missed something?
No, you're good.
It's Friday late in the session.
I hear you. That it is. So anyway, at least the last version to this version, we, if I remember, lines struck or dispensing, that was actually meant to be struck. That was just a typo that never was anyway, because dispensing was struck in line 7 and the underlying bill is inadvertently not struck in the title as well. Going back to the existing penalty, I think was what the committee talked about. That's line 13. So rather than make it a 5-year felony, keep it a 2-year misdemeanor.
This says 2.
Yeah, 2
Right.
years. That makes it a misdemeanor.
Yeah.
Oh, I thought you said 3.
No, well, you talked about that, I think, yesterday, but settled on 2, I think. And then you sort of keep in the language, it's D and B are connected. It's sort of a safe harbor for a landlord in this situation to be able to avoid criminal liability if they make a report to a law enforcement officer or start eviction proceedings. And lastly, striking the definition of recklessly and leaving that up to the courts and the common law.
Oh. I just need a little reminder on page line 13. We went from 5 to 2 year, but from 1,000 to 15,000. Why that jump? I don't remember why we went from 1,000 to 15.
Well, I was just suggesting we keep the 15,000, which is what the Senate put the 15,000 in there.
Oh, it wasn't 1,000. Okay.
Hurt the pocketbook a little bit more.
No, that's fine. I just wanted to.
Section 3, the same changes that we just said, because this is the permitting human trafficking in the dwelling that you own or control. So again, it goes to the 2-year misdemeanor, line 9, strikes the definition of recklessly. All right, let's see. So then in the next 2 sections, sections 4 and section 5. Section 4 is defacing a firearm serial number. Section 5 is straw purchasing. The 2 changes here are exactly the same. It's on page 10, lines 8 through 10, and lines 7 through 9 of page 11. And that's striking the language that said that conduct would constitute a violent act for purposes of determining bail eligibility. Moving on to section 6, this is the prohibited persons piece of the bill. Remember that there's various categories depending on whether or not someone's been convicted of a certain crime, for example, or these are tracking federal categories that already exist, adding to the criminal conviction prohibited person statute that Vermont already has. So the proposed change here is that rather than it be anybody who's subject to a final order against stalking, it would only be, you see, if the order prohibits the person from possessing a firearm. So if that were the case, then they would be, it would also be a separate criminal offense for them to possess.
Wait, that doesn't, and my brain's computing that as like, oh, so they're doubly prohibited?
This is making it a crime. So the fact that the person, let's say they were subject to a final order against stalking and they were, the order said don't possess a firearm and they had one anyway. They certainly could be held in contempt for violating a court order, which can be a criminal offense also. Not 100% certain if there's a separate crime for violating a stalking order. Possibly there is, but this makes it clear that it's a crime to do that. So it's not just that you violated a court order, it's a separate independent criminal offense. Over on to section 8, which goes over on to page 14. This is, remember, allowing the court to provide the National Instant Criminal Background Check System with records related to a background check when a person is under, you see the age has changed on line 5, page 14, under age 22 rather than under age 21 when they seek to buy a firearm. The reason for that is that in Vermont, some of those records, because you can get youthful offender status up through age 21, if you just had it under 21, you wouldn't necessarily be allowing them access to all the records. So under 22 is accurate for Vermont purposes. Section 9, page 14, this is the Community Violence Prevention Program, adds one party that has to be consulted with by the Department of Health, the Council for Equitable Youth Justice. Over to page 17. This is the
Council for Equitable Youth Justice is something that is.
I believe it's in a separate bill. It doesn't exist yet.
H-175, the Amy Davenport bill, that's what it's going to become.
It's going to develop this.
It's renaming an
It's-
existing.
Renaming.
Yeah, that's being renamed.
All
It's the- it's the one that Amy Davenport is.
All right. Just do we know that that's going to get through?
I think it's, I just wonder if we should give it, it's certainly voted out of the Senate Judiciary. I thought, let me see.
You could just add formally referred to as or something.
I don't think we.
I think you can hold off on it for now. And
Yeah, I think
Keep an eye
by
on
the
it for
time
our-
this is hitting the floor, we will have seen what's happening to H-175. So we'll just keep an eye on that. Yeah, it's in appropriations right now. Senate appropriations. It already went through finance, it's in appropriations, so I don't think it's gonna take long because there isn't, it took hardly any time in our appropriations.
So what would happen if we passed this out first and that thing wasn't even renamed yet?
We'll just make sure that we don't pass this on.
Okay. That's kind of where I was going. So, but what's the answer to that question?
it wouldn't be an issue if the other bill passed eventually.
Eventually, okay.
Yes.
If not, we might have to go back to it next year and say, oh, there's no such
Technical
entity.
correction.
Yeah.
If it doesn't pass, I will put it in my technical correction file for next
Right,
year.
it just is an entity that doesn't exist.
Right, yeah. Just a small technical.
Right. I have to think that one I'm pretty confident is gonna make it through.
Well, no, and I understand that, so I was just kind of going hypothetical, what the heck would happen? Yeah.
So the last thing, Eric, you have on here, I see the
Yeah, so the plan,
National Firearms.
so actually just
Got something
note for a second that expanding the people who the report on secure.
Oh, right.
There's a report on the raise the age implementation that has to come back. Just expanding the committees that the report has to go to, that's page 17. Over on the page 19, we've already talked about these new sentencing commission looking at whether to expand the Big 12. That's page 14 and page 19. And then, as Representative Lom was just mentioning, the last section is new, starts really page 20, 21. This is something I talked about. I know I talked about the language in here before. It has to do with the exceptions for possessing firearms.
To go on that one right now, we had a straw poll earlier.
Oh, okay.
To put it into the miscellaneous,
Oh, sounds good.
including with the change from Jessa.
Yes. Yep, that's in here already, actually.
We're good with that.
Okay.
I did want to hit on two other things, and I want to ask the committee about this before we break for the floor. There's a lot of stuff in here that I think is very important. And I see this bill having still a bumpy road to get all the way through. There's one thing in here, there's 3 sections in here that I would think are must pass. And that would be section 11, 12, and 13, related to the date for raise the age. That they are not prepared for that date or for the raise the age next step to happen now. I mean, that goes back to other parts of S4 where they don't have the secure placements facilities yet. So my suggestions, we're keeping it in here, but my suggestion is to belt and suspender this and to put those 3 sections in the miscellaneous bill as well, just to make absolutely sure that we have it covered, because like I say, the S4 has a bit of a uncertain path.
So are we gonna have any witnesses come in and give their opinion on these changes, or?
Probably not, but we could talk a little bit further about that. So, can we're going to break until 3 o'clock or 15 minutes after the floor, whatever comes later.
The floor.
How about immediately?
5 minutes.
How about 3 o'clock or immediately after the floor, whichever comes earlier?
Okay.
It'll be before 3.